So in Ontario, we don't have one level of court. We've got two, not including the Court of Appeal, Divisional Court. If you're in a family law matter, you don't have to try negotiation and mediation. We're trying to make it go that way. There's many jurisdictions, especially in the United States, where that is something that has to be a first step. If mediation doesn't work, not all parties are suited to negotiating or mediating. Some people just simply won't agree, even if there's a skilled professional trying to help them. And if they find themselves then going through the court process, you have to know what level of court to commence your matter in. So in Ontario, all matters start in family court with an application, a Form 8. So when you're putting in your Form 8 with your client, there's a fairly new form called Form 35.1. It's a sworn affidavit. It's 35.1. It's got to, if there are children involved, it's got to accompany the Form 8, or it simply won't be accepted by the court staff. Now that's more to do with child care issues, who is the primary caregiver for the parent, who lives with the child in the home, are there any criminal records involved, any criminal charges pending for anybody that has day-to-day contact with the child or access with the child. And that's been developed, I'd say, in the last 4 years or so, because there were some instances where boyfriends, girlfriends, grandparents, aunts and uncles, caregivers were stepping in who perhaps shouldn't have stepped in. Children may have been harmed or not given the proper care. So this is the government's way to try and make sure that, the court knows who's involved with the kids' lives. Now also, I think you heard from Mike that there's a financial statement that has to go in with the initial application, unless the initial applicant is a recipient, who's a child support recipient, who is not expecting to share the Section 7 or extraordinary and special expenses for the child. If that's your recipient, she does not have to go, or he does not have to go, to the expense of the time and trouble of filling out a Form 13 or a Form 13.1. And that's a good thing to know. It's the rare circumstance when you don't have to fill out your financial statement, or your client doesn't have to fill out the financial statement, but a lot of people would rather not. And if they don't have to, why would you want to disclose all of that information? It can be very private information. You wouldn't want to necessarily do that if, let's say, your client is simply seeking child support from the other side. Her income's not relevant, his income's not relevant if he's the recipient, so you don't want to have to put your client to that expense. Now, I should ask you, and look who I'm going to ask, maybe someone can give me the information. At what point do you typically become involved with a client who's divorcing? Do you get referrals from lawyers? Will your already existing client come to you and say, there's been a breakdown in the relationship?
It's all over.
Yeah.
So it's less before the lawyer. Sometimes the lawyer refers them. Sometimes they're working with the lawyer and go off on their own and find financial crisis.
So you're probably very careful then if someone makes contact with you, a client that say you already have, or a client that's heard about your financial services, you're probably very careful not to give legal advice. Am I right?
I was going to say, if they come to me before they've even seen a lawyer, my first recommendation is go and get your rights. Make sure you're aware of those rights, and then we can work together to.
I'm so glad to hear that, because lawyers face that issue oftentimes ourselves. We have something called, a lot of us anyway, meet a client for the first time at an initial consultation. And that client might sit down and say, solve all my problems. What do I do here? We've just met that client. Most initial conversations are an hour and a half. The client meets us, we meet them, we talk about rates and fees and issues and how to move forward. I think Mike had a nice, I don't have his PowerPoint with John Greenberg, but he had a nice list there of lawyers' responsibilities. When we go through the court process, alternatives, mediation, all of that. And I was just at a conference this weekend in LA. It was more child-focused, not necessarily financial, but a big hot topic was self-represented litigants. And if you're helping them with the financial end, they may try and lean on you a little bit more for some legal advice. And that can be a danger. One of the presenters at that conference, he was a professor, I think, at Hofstra, and he said, I'll give anybody here tenure if they can tell me what the difference between legal advice and legal information is. And we all said, oh my God. Because these are questions that you probably face, I face. I can't give someone independent legal advice on their circumstances when I haven't seen their finances. I don't know what the other side wants to do with childcare. So there's just too many unknowns. So these self-represented litigants find themselves going to court, speaking to the CSOs, the court staff, people that can take in applications, people that are aiding judges, people wandering the halls sometimes that have other work to do. They could be bailiffs, and they'll be stopped. And someone will say to them, what do I do? Here's my situation. What do I do? Anything more than a procedural question, the court staff can't answer. So then we hear about the self-represented litigants who say, I went to the court and nobody would help me. So it becomes this whole quagmire. So I think that the more you know about the procedure and point them in the right direction where they can go for more in-depth advice, the better. So to start off, like I was saying, there are 2 levels of court in Ontario. If we don't have a unified court system, if we don't have something that's rather new, I think they first started in the 80s in Ontario, and they haven't caught on as well as some of us would hope. If you don't have a unified court that follows the principles of the Superior Court of Justice, i.e. it can deal with all issues, then we have 2 levels of court. We've got SCJ, the Superior Court of Justice, and we've got the OCJ, the Ontario Court of Justice. And both work well, and but they can't work together. So if you've got a judge from SCJ, you won't see that judge in OCJ. If you've got any type of a property issue, usually or in the past, we would always say, well, if the parties are married, the procedure goes under the Divorce Act. If they're common law, it's going to go under the Family Law Act or the Children's Law Reform Act or what have you, provincial legislation. They go to the OCJ. The people that were married, they have to go under the Divorce Act. That's SCJ. Well, it's not so simple anymore. Common law spouses, I don't know if you follow your case law, it was in the news, though, Karen Baranov, joint family ventures have taken over what we used to call a constructive trust. So parties that used to live, or parties or spouses, common law spouses that live together, usually for a fairly significant period of time, can acquire rights on property held solely in the other person's name through a constructive trust, or as we like to say now, a joint family venture. So things get complicated. And if someone's going to assert that claim, it's essentially a property claim. So if your client is in that situation, and they say to you, I'm going to bring an application, what should I do? You might want to say, consider the level of court you're going to be applying to. Because that could trip them up right away. I don't want to jump ahead, but I have an interesting story, or I found it very interesting, to tell you about what happened to a fellow that eventually did come to me. And before, he's a fairly sophisticated fellow. He manages probably about a dozen people under him, an intelligent man. He got tripped up. It cost him some money. He had a cost award made against him. So that's the problem. What he did was he had a separation agreement. In that separation agreement, and I am skipping ahead a little bit, I'll backtrack a little bit. So we talked about when a court has jurisdiction over property issues. You're going to be in the SCJ. When it's more of a custody or support issue and there are no property issues, you could be in the OCJ. But what happens if you've got your matter fairly resolved already? So you've met with your partner, with or without lawyers, and you've devised something called a separation agreement. What do? Well, hopefully, if it's a properly prepared separation agreement, there will be something in there, a section called dispute resolution. Again, leaning on Mike. It'll tell you if there's a problem with childcare, if there's a problem with support, if someone's not satisfied with the level of spousal or child support, what are they going to do? Are they going to rush to court? Are they going to negotiate through counsel, negotiate themselves first? Are they going to jointly engage a mediator? Will that mediator then also be able to become an arbitrator if the mediation fails? Or will it not? So all of these things, will they go to collaborative law and try and resolve their issues that way? So there's all of these things to consider. And if you have put I guess, limitations on when you can return to court, certain steps you have to take first before you can go back to court. When it comes time, you have to remember that. So it's always a good idea to speak to clients who may have been divorced. You know they've been divorced 2, 3 years ago, 5 years ago, 10 years ago, but they're still in contact with that person. There may be children, there may be ongoing spousal support they're receiving or paying. If they come to you and say, you know, I've engaged my family law lawyer again, or I'm thinking about it, there's some issues here that I want to change, even though everything had been settled, I would always say to them, you just want to make sure you reread that document that you have. Whether it's an order, a final order, whether it's a separation agreement, have a look and just see if it says anything about what your first step should be. If it doesn't, I'd be surprised, but there are some out there who don't mention it. And if it does specifically say the parties will try mediation, hopefully it'll say day or a half day, but it could just say mediation, then you would ask that person to make sure that they contact the other person in writing, via email or text, suggest a mediator or 3, have that other person choose one, and go down that road first, and perhaps give them a deadline. Now, I'd like to mediate. I have a problem with this section of our agreement. I understand from this dispute resolution section that we should go through a mediator first. Please get back to me within 15 days. If they don't, I would then advise sending another text or an email. You get an email, on it goes. And if that doesn't work, then the person can take alternate measures. Maybe bring the process back to the court. I have a situation, and, you know, again, my client, very sophisticated man, never got along with his ex-wife, and there's a lot of animosity there, and I think his blood would start to boil whenever there was an issue of any kind. And he went right to court. He'd signed a separation agreement. I wasn't his counsel at the time. He didn't have counsel, and he went to court. Now, she had counsel, so immediately his wife started to incur legal fees. And the first thing her lawyer said, I imagine, to her and likely to him at court was, you started the wrong process. You know, the court doesn't have jurisdiction right now. Your jurisdiction is written down in your separation agreement. Here it is. And, you know, what are you doing here? And it went on for a little while. There were a few court attendances. Sometimes people see someone called a dispute resolution officer before they get in front of a judge. I can't imagine if they'd gone in front of the judge at the next step called a case conference, an informal chance to settle. I can't imagine the judge would have let it proceed. But like I say, I wasn't there. What did happen is my client got a $2,200 cost award against him. So finally, when he did get in front of the judge, opposing counsel, I'm sure, made it clear, you shouldn't be here, you're wasting my client's resources, improper jurisdiction. And so he's, I wouldn't say barred, but it's pretty difficult for him now to get into court with an outstanding cost award. I have steered them towards mediation, so they're going through that process. It's likely not going to succeed, given who these people are, and then we'll have to go back through the court process, but at least he won't be jeopardizing his success. Okay, so right from the beginning, he was in the wrong place. I had another situation where my client, again, the parties had separated. There was a separation agreement. Though they had been married and they divorced, the wife brought an application for some type of support years later. So we ended up in lower court. Fine, you know, no problem there. It's a support issue. Midway through the process, she said that he had some property somewhere in the south. You know, hadn't been disclosed to her when they had dealt with property in the higher court years earlier. She wanted to deal with it now. So I said to my friend, opposing counsel, we're in the wrong court. If your client's going to make this claim, she's going to amend her application so we know what we're dealing with here, and you have my permission to do that, no problem. You know, please get it to me soon, and that's going to bump us from OCJ, we're at 47 Shepherd, the closest court to both of their homes is Brampton. Now, my friend's client didn't want to go to Brampton. She had some transportation issues. So we said, well, we can agree it's at 393 University, if that's better for your client. He wouldn't agree. He said, let's keep it in this court. And that was counsel. And I said, how can we keep it in this court? Because the judge won't deal with this issue of property. And he said, well, it's been adjudicated. But he was a clever fellow. He said if a process, he cited his rule, if a process has been adjudicated, you can't switch courts at that point. Now, what adjudicated to me meant, and thank goodness it meant the same to the judge, adjudicated meant decided. Now, we were there, it was early days, we were at the beginning, there had been no adjudication, no decisions had been made, no rulings made, no agreements negotiated or entered into. Yet we went to a motion. We wanted to move the process to the proper court. We won our motion, but my friend spent 45 minutes talking about adjudicated, and we brought up the Oxford Dictionary and the Black's Law Dictionary. We went through the whole thing, and it cost everybody a lot of money. And that was counsel. So you really want to make sure if there's any property issues, or if the parties are married, your clients are going to SCJ. If they discover a property issue later on, they go to SCJ. If not, it's just going to take more time, cause delay, and cost everybody a lot of money that they didn't need to spend.
Can I ask, at the beginning you mentioned that it may not be necessary to provide a full disclosure in the certain situations.
The financial disclosure.
However, yeah, financial disclosure. However, if something comes up later, it can be used against the person who didn't disclose it at the proper time, and then might be used. So I know it's usually recommended to do disclosure, doesn't matter what.
Well, and I'm glad you brought that up because I want to be crystal clear. If there's any issue other than a recipient looking for child support. So if the primary resident parent is not receiving enough child support in his or her mind, or hasn't got an order for any child support, that person can put in their Form 8, the application, and they can put in the Form 35.1. They don't have to put in the Form 13 or the Form 13.1. Mike probably went through this. Form 13 is for common law. Form 13.1 is for people who are married, because there's likely going to be property division, so there's some different columns in there. But if someone is not seeking a contribution towards the Section 7 expenses, so those are things like medical and dental prescriptions or medical and dental expenses not covered by insurance, summer camps, daycare, things that are above and beyond child support. If that person is not seeking a contribution, their income is irrelevant. If they are, they're just seeking table child support. So
If they want it later, in the other part of it, maybe confused everything and if used against the person?
it can't be used against the person unless there are other issues. So if it's like, I did say this, it's rare that you would have a client who just wants child support. But it's not unheard of. There are parties that have lived together, there are parties that don't accumulate property, but they have children, so there's no division. Parties that aren't married wouldn't consider it a division anyway unless someone was making a joint family venture claim or a constructive trust claim, as it used to be called. So I wouldn't take away that, try not to give financial disclosure if you can. That's not what I'm saying. It's simply not relevant. And a lot of people are very glad to hear that, especially if they are the recipient and they don't have a high income or they don't have a lot of assets. They feel uncomfortable sharing that and providing that information. They feel like they're, and I've heard some recipients tell me this directly, they feel like they're begging for support. And they don't want to show everything. And I've said to them, child support's your right. It's the right of the child, actually. Don't feel that way. And you don't have to do your financial statement. But if they do want a contribution to those other expenses, most people have other expenses for children beyond food, shelter, and clothing. If they want a contribution, it's on a proportionate share. Mike probably talked about that as well. And if you're going to seek a proportionate share, you obviously have to disclose your own income. And
What about the other part, the other person who will be paying support? Do they have to disclose?
yes,
So then the first one is not, but the other one must.
yes. Now, yeah, the payor. The recipient doesn't if that's the only issue. They're just seeking table child support. So I'm sure Mike talked about the federal child support guidelines. If your income's $50,000 and there's 2 kids, boom, you got to pay this amount a month. If your income's $60,000 and there's 1 child, boom, you have to pay this amount a month if you're the payor. That doesn't require the recipient's income. So the recipient could have won the lottery. He or she could have $1 million in their back pocket. That does not reduce or change the table obligation for the payor. Yeah.
If there was some division of property that they agreed upon,
Yep.
but then they were only looking for the child support in addition to whatever they agreed there, could they sort of come back afterwards
Yes.
and argue the division? And if that Form 13 wasn't filled out, I think, does that create a problem at that time?
I would not advise my clients to seek anything other than child support without full disclosure. So let's say there's a side agreement, if I'm understanding you correctly. Let's say separating parties, they've divvied up everything. They've sold the house, they've split the net proceeds, they've separated and taken whatever they wanted, they've divided the contents. There were no RRSPs, no pension, no investments. That's it. But the payor decides for whatever reason he or she won't pay the child support. In that case, I would say, yes, this is an application for child support. But if my client said to me, I don't know if he had a pension or she had a pension, I don't know if there were RRSPs, I have some, I think they're equivalent, I have a $30,000 RRSP, I think he's got 32, I'm not going to bother, then I would say, do full financial disclosure. Because you don't know what they have, it's a sworn statement when you do it, it's a sworn statement when they do it, and you may be disadvantaging yourself by not making that requirement. And you have to make that claim too. I would also tell them to check off the equalization box. If you're going to court anyway, they have some unknowns or some suppositions that they can't validate. It's my duty as their counsel to dig a little deeper. And it is, in family law, one of the basic tenets is full financial disclosure. That's why I say this is a little bit rare. You don't give disclosure for no reason. You give disclosure to give information, right, and support what you've said. If the other side doesn't need your information because your information is irrelevant, you're a support recipient, your income's irrelevant, why would you give them that information? There's no reason for it. In almost every other instance, there's a reason for disclosure. And the risk you could run of not providing full disclosure is if people have these kind of, we met at the Tim Hortons, he's got a $32,000 RRSP, I've got a 30, we're going to call it even, we're not going to hire you for that purpose. I would have them sign something called an acknowledgement saying, I acknowledge Ms. Vanderschoot advised me not to do that, and here are the reasons why. And some of those reasons would include you could disadvantage yourself, you're waiving your right to assets, you don't have full disclosure as to whether or not they exist. And any agreement that you sign could be non-final. It could be reopened rather easily if neither party made full disclosure. So, you may say to your client later on, how do you know he didn't have a Swiss bank account? Or how do you know he didn't have a full pension? And she may say, or he may say, I don't know. And you know what? I've heard rumors from brothers-in-laws and friends and people we know. Go ahead.
Just to add to that, but this is all items that we should have had at the time of separation, leading up to separation. Anything post that date is not going to come into question.
Well, but if you had a pension, let's say you were married for 12 years or 15 years, and on the date of separation, you're sitting at the Tim Hortons trying to do things yourself and not involve lawyers and go to that expense, or we have something now called unbundled legal services, which means you can talk to a lawyer, you can hire a lawyer for specific and isolated purposes. So you might say to your family law lawyer, I met with my financial planner. I'd like you to help me do my Form 13 and my Form 13.1. And the lawyer can help you with that. But any good lawyer, I think, would at least talk to you around some of the issues that may be brought up when doing a financial statement. One of the things I would say is, if you're not honest on this document, you may be perjuring yourself, number one, it's a sworn document. Number two, you want to put in full financial disclosure with supporting documents. So if you say you have an RRSP of $30,000, print out a statement and include it. If you say your income is $54,972 for 2012, give us a copy of your notice of assessment to include. Because if you don't take those steps, you run the risk of an agreement not being final. The other person can come back and say, let's reopen this, and that can cost you tens of thousands of dollars to defend.
So quite often clients do come to us to help them with 13.1.
Okay.
So They've gone to, and I've had this instance as well, they've gone to their lawyer, left a nice hefty retainer, and the lawyer's given them a list and said, go do it and bring it back to me. And they have no idea where to start. So, I mean, they've visited a lawyer already. So for us, we will complete the form, or I've completed the form, full backup, full proof of everything that's gone on there, and then that form gets emailed to the lawyer with all the supporting documentation for them to take from there. You don't see anything obscure to that or something wrong with that. We're not doing anything financial in that regard. We're compiling the information on their behalf so that you have everything that you need to take them forward at that step.
Well, and in our law office, and in many of the offices I know about, what we do is save people money. My hourly rate is higher than my clerk, let's say. So what I do is I would say to my client after I meet them, I send them an email, I say, here's the financial statement. It can be disconcerting at first. I don't know if you've ever seen one, but, so we found one for 13.1 only that has instructions. So it looks even worse when you first read it. It's triple the size, but there are instructions. So usually I say to people, don't panic. Read it over, put your pen down, read it over, get an idea of it, and don't panic when you first see it. Read the instructions, and there they go. But I also say to them, if you have any questions, contact your financial planner or contact our clerk. Now the reason not everybody has a financial planner. We know that our clerks know how to do these forms. The only thing I would say to you, and I don't know how much Mike, again, went into the financial statements before, there's a few things there that may not be intuitive. When I was a new lawyer, I did a few financial statements, and your clients our clerks send them a list of the disclosure, RSPs, investments, and all of that. Some of the things, I just had a client recently who did quite well. His income was reasonable, but he would get RSIs, thank you, and RPUs. So they would vest over time. They used to vest over 5 years. There was a change. They used to then vest over 3 years, and on it would go. So we would say, okay, his compensation, his bonus was made up of $80,000 of RSUs. We don't know what the value of those, let's say he got them in 2008, the date of separation is in 2010, what was his net worth in 2010? Well, I would hire a evaluator. Now the problem with that again is we're talking about $60,000. It'll cost him $7,000 or $8,000 to have those valued. So we actually had to, and we did it at that time, he really couldn't get away from it. If it's your asset, you likely have to pay to value it. But I'm not sure if that's something you would do, or if you have...
We could identify those as well, and then we would notify you to say this is what we've come across. Would you like us to proceed to get the evaluator for you, to get it done?
Okay. Okay.
That's why.
So you wouldn't put down a value or try and read?
No,
yeah, okay.
Because I
wouldn't
can't
have
do
to.
it. Exactly. So I know our limitations. I wouldn't be able to value that.
Okay.
And I'd say we need to get this valued. It's going to cost so much. But then we'd notify, I'd notify the lawyer and say this has come up.
This is an issue. Well, that's perfect.
Sometimes it's based on performance of the company and the employee in terms of what it's actually worth.
Exactly. It's overall profit, it's meritocracy, it's a whole bundle of things. You have to read, what his employment contract says, what his bonus structure is. And this was a company that had recently undergone a change. Their pension had also changed, by the way. The pension had been a DC, and it went, yeah.
I was going to say, this whole Tim Hortons talk thing,
Yeah.
I can't see that going anywhere
That
because,
is
people just don't understand what they have, whether it's an RSP, a TFSA, defined benefit, defined contribution. They just...
My client had no idea,
Yeah.
and he was making hundreds of thousands of dollars a year as an executive, doing an excellent job in his field, but he's not an evaluator, and I'm not an evaluator, and I wouldn't claim to be. But if there are issues, as long as you can identify those issues, you're doing your client a service, and you're helping the lawyer. Because some clerks could miss those issues too.
Yeah.
Well, I think that's a part of the whole piece, because when you do get clients that are more complex, it's more of an education process as well.
Yes.
That you need to sit them down to explain, this is the type of asset that it is, this is what you're looking at, this is why we're this is the value we're doing today. So it does help to bring some education to them, which makes them a little bit more empowered when they come to see you, because then they know what they're up against.
Well,
Some
exactly
people don't
right.
even have an idea, especially if you have one spouse that's like, say, an approved RSP, and the other one's in a defined benefit plan, they're going to say, the defined benefit person doesn't even realize what the value is. Whereas they see the other group RSP statement, there's, a clear
They
value.
can see it.
And they don't even think of the pension as a value, or how to value it compared to that RSP.
Well, this is what I was going to ask you too. When you're doing financial statements too, some clerks forget this too, and I don't know how, but you're aware too to give something a notional disposition cost.
Always on
Okay.
contingent liabilities, anything else that exists.
Excellent.
But it's
Someone
probably,
can
but
help.
it might be because we're financial divorce specialists. So
Yes,
we
okay.
we've had the background.
This is
in
what you
that.
know.
So
You're
not
doing-
all financial planners will have.
You're right. They simply they won't. I mean,
They
a lot of
won't.
my clients say, well, what's this? My RSP is worth $10,000, and what's this minus 3,000 or 22 or whatever? And you have to explain it to them, and they're happy because it's lowering your net income. But even that concept, a lot of people don't get that.
Capital gains and everything.
You know? And but sorry, you had a question? Okay.
I have a question, just to clarify, when you were giving the example of why you might not have to do the Form 13,
Yep.
if you've got a two-income household
Right.
and both of them are responsible for child support, for a portion of it, would you not have to have a verification of income from both sides?
No. Now, if you're talking about Section 7, for both people should pay a proportionate share. So, if there's, let's say hockey, and the child's really good, he's in AAA or, he's up there, then yes.
No, I'm
There's-
talking about the basic
The
needs.
basic, no, there's not an obligation, because this is how it's viewed by the courts and the legislators. If you have a child living in your home, you're intrinsically providing food, shelter, and clothing. You're not quantifying it, you're not writing yourself a check or, sourcing it out like that. So for the other person who's not in that home and who's not automatically providing those things for the child, it is quantified. So they're giving a portion in relation to their income. So that's why if you see Mike Cochran did the support calculation, they can do them now where they look at your total gross income and they say, what are your other obligations? Do you have some Section 7 obligations? Is it straight table support? Or is there spousal support obligation? Because they want to work it all together. If you earn $50,000 and your child support obligation is $500 a month, you can't also pay $3,000 a month in spousal. You probably can't even pay the $500 a month in child if you have a spousal obligation, or you'll pay less than spousal because of that. So they're interrelated. They quantify the person who's not the primary resident parent with the child, because the primary resident of that child, they're just providing. And likely, they're providing more, and always will. That's a controversial statement. But the primary resident parent, they're buying shoes, they're buying all these things, and it's difficult to say at what level, and it can work the other way too. I mean, I have clients who are very high income, and they'll say, why am I paying $8,000 a month in child support? And then they may ask the court, if your income's over 150, the child support guidelines may not apply. Really, my principal actually is responsible for a case called Baker and Francis, where the concept was challenged of a payor whose income was, I think it was $1 or $2 million. He was paying a huge amount of child support. So his complaint was, it doesn't cost that much to provide food, shelter, and clothing for a child. Why am I paying that much? The excess is going to the former spouse. I don't like that. It doesn't sit well with me. I understand that the federal child support guidelines should be capped at 150. The court came back. This is a Supreme Court decision, and they said, no. They said maybe if your income's around 1.2, 1.4 million, we can talk about a reduction. It's not automatic. So when you have people saying to you, oh, I understand, my income is 300, I only have to pay child support on the first 150. That's an inaccurate conclusion. And courts really don't take pity on payors unless their income's really high and that child support obligation is going to be outlandish. So something to keep in mind.
So it's just sole custody that you're talking, so they have to have, it's just a
Primary residency. Yeah,
primary
so,
residency.
Primary residency. So custody is more about decision making.
Right.
Yeah, it's confusing because I get a lot of American TV. I have people coming in saying, "Where's my prenuptial agreement?" Marriage contract, cohabitation contract. But in some of the states, I just came from LA too, and we, sometimes the Canadians were tapping each other. What are you talking about? Custody a lot of the time, not in all states, but in a lot of the states, custody is about where the child lives. So we get that, and that's a misnomer, I think, that's made its way into the Canadian vocabulary. But in Canada, custody is decision-making about important decisions, usually medical, educational, religious decisions, very, very important life-changing decisions. Not, if you scrape your knee, put a Band-Aid on it, that's not a medical decision for decision-making purposes, for custody purposes. But,
Yeah, so, because I said sole custody. In that case.
Okay. So if you get to a split, a shared parenting,
Yeah.
so it's between 40 and 60%, so and 50-50 or anything close to it. We have people counting minutes. We've got a famous Canadian case called Contino. And you mention it to a judge, you're in trouble, because that judge doesn't want to be the Contino judge. Do you count overnights? Do you count when the child's asleep? Do you count time when the child's at school? Vacation? What is it? So time in the car, getting from one parent's house to the other. I mean, it gets absurd. And in that case, I believe it was found to be 39.1 or 2%, so the person didn't get into set off.
Right.
So it's not automatic, but basically what happens if mom and dad have a 50-50 and they have relatively equal incomes, even I would say 55 to 75,000, one earns one, one earns the other, they may pay no support. If it's 150,000 and 20,000, they're probably going to pay full table support. There may be a set off, but that person would have to make the argument. If there's 200 to 50,000, yes. So basically what's done then is the table calculation. What do they pay on 200,000 for 2 children minus what would that person pay on 50,000 for 2 children? You get a number. And that number can be negotiated up or down. But the point of the court is that they don't want a child moving from a home that has to a home that has not. That has consequences and, results of where the child wants to be.
So where the child support calculation is established, do they need the Form 13?
Yes. Yes, for
That's what I
sure.
was trying to say.
Yeah.
For sure. That's what I was thinking.
The
Well,
shared-
how would you do this if you didn't verify that other person's income?
That's right. That's exactly right. Now, I was talking about a more simple situation, which you probably
Where
never
there's one
see.
primary.
Of course, it would be nice, but yes.
Can I just ask you a question?
The spousal support is
Yes.
the 350 cap.
Yes.
So what is your opinion, or what do you see on that? Because
Similar.
like the 350 doesn't really stand, right?
Not at all. Now, I actually have a case right now where a fellow earns 300 and his bonus is usually 275 to 300. So obviously a substantial part of his income is his bonus, almost half. And opposing counsel made that argument, of course. So I did my case law research and just looked a few things up, and it's the same. It's similar. It's if he was making 1.3, 1.4, perhaps. But then again, there's other factors that come into it. My client is probably close to 70. It's a traditional marriage. She raised 2 children. It's a long-term marriage. I think it's about 35 to 40 years. So there's really not a judge in the land, if it went to court, that would say that she shouldn't receive a substantial amount. And he should keep the lion's share, and she should take a lot less. I mean, there's also case law that says that a bonus of that size potentially shouldn't be shared 50-50. Maybe it should be 41 to 46%, I think the case law was telling me, because he does have added expenses of being out working. Okay? So he's got to do his dry cleaning, or, he's not a homemaker, so he's got to hire someone now that she's no longer there. If there's childcare obligations, he'd have to hire someone, he's not there. So he incurs more costs due to his work.
So in general, you don't see it locked in like that's it.
You really don't. No. I mean, I don't even actually know why those 2 caps still exist for child support and spousal support, because they're really not caps at all. And they just create more confusion. And the other side, I know his counsel, and he knows what I've just told you. And I've said to him, therefore, you should get your client to negotiate, because if not, we're going to end up in court. Your client's going to lose. It's going to cost everybody tens of thousands of dollars. And he said, he heard this somewhere.
Yeah.
The 350.
That was
And
a
he's-
Morning.
Probably. So, and he's digging his heels in. He doesn't want to later. Go ahead.
Yeah, the divorce rate, that's where it has that
Yeah,
350.
I know.
Yeah. Now,
I know.
one thing that I ran in with divorce rate was a common law couple, that they have a child, the like during this time.
Okay.
Should be a child. So I just kind of ran some calculations. They weren't there just to kind of take a look, and it said the duration was, because the child was 14 months. The duration of the spousal support was from 2 to 16 years.
For spousal or child?
Spousal.
Too?
Yeah.
I had that recently as well, and I'm actually going to court June 11th on it. And it was a 4-year relationship. At the time, I think the worst part about this case, imagine this, everybody. Don't write this down, it's just too sad. I wasn't his counsel. So there was an interim, so a temporary order made for spousal support, and judges will make interim or temporary orders on less evidence because they know there could be a need, could be a year or two until there's a trial, but they expect that trial to come up, right? This order was made in 2002. My client, for a 4-year relationship, there was a child as well, a young child, and I looked at the spread, and it was between 3 and 15 years, which, would be 15 years for spousal. As soon as the child reasonably, and this will differ depending on what judge you're in front of, which it didn't, but it does, as soon as the child is in school full-time, there's an expectation that that person will become self-sufficient. If they can start training while the child is in school part-time, night course, do this kind of thing, there's an expectation in the Divorce Act for self-sufficiency. So, to make a long story short, just to let you know what's going on June 11th, so, for whatever reason, this fellow was paying $4,000 a month in spousal support for the last 11 years. It should never have
Can I
happened.
ask you also, if they decided upon separation, then this will be unequal division of property. One get more, the other one get less. And they signed the separation agreement, everything. Can that person who agreed to take less come back later and demand the difference?
Yeah. They can come back under various heads of relief, so they can reopen the agreement. The best and easiest way to reopen an agreement is if one or both of the parties did not have independent legal advice. So we
They
always,
did have independent legal advice.
and the certificates are signed?
Yeah, full disclosure, and then for some reason they decided one get more, the other one get less.
Okay,
And
then-
the one comes still back and fight for that portion.
Yeah. That happens. It even happens today. And their heads of relief that have now shrunk in with those further details, they could come back and say that they were pressured. Now, a court may not believe them because they had a lawyer.
Yeah.
But lawyers don't follow you home. Lawyers don't know if someone's threatening you or doing something. We always ask, but if someone's truly terrified, or some people actually just give up, they can't take it anymore, they decide to settle for an agreement that's not in their favor. The second head of relief, so they could try. They could say they were pressured into signing the agreement. They had to sign it by a certain date, or something was going to happen to them. The onus rests on them to prove that as best they can. The second would be that the court, for whatever reason, finds it unconscionable. So the agreement that the person signed is unconscionable. Now, you can imagine it's hard to shock the conscience of the court. They see all kinds of terrible things. So if someone got to keep $1 million and someone got $10,000, and they don't have a lot of, and that's an extreme example, but if they didn't receive a couple $100,000 or something, the court's probably not going to be too upset if they got a substantial amount. But it has to be something that shocks the court. It will help the person trying to open the agreement if the other person did hide something or downplayed it, acted in bad faith. But then again, if I were acting for the person who wants the agreement to stand, I would say, sue your lawyer. Because we've had independent legal advice.
So if it was like the 40-60 split and now you're trying to get the other 10%.
Well, you probably won't, though, because remember, if it's spousal support or something like that, you probably won't, because if it's 41 to 46%.
That's what I'm saying, yeah.
Yeah.
But even assets, I was talking about assets.
Assets, division of assets.
Same idea.
Yeah. No, you'd have to tell me though. Why would the person settle for that unequal division?
Because there was a little bit different case. One client, wife was working,
Yep.
husband was kind of sitting home, okay? Never, like, he didn't work. And when they
That's it.
split, he took less than she does, okay? Can he still come back after her?
Well, but it's part of a total settlement. So hopefully in the separation agreement too, it says that none of these certain paragraphs, whether it's spousal support and asset division or whatever.
No, just
Okay, so somewhere in the agreement that hopefully it says all of these terms are intertwined, In other words, he agreed to no support because he got more assets, or he agreed to no support, and if they're intertwined and their settlement formed a comprehensive whole where you can see a trade-off. If you can see, now your case, if I'm understanding you correctly though, he sat at home, didn't do much. So what, did he have a crisis of conscience and he didn't want to take from her? He recognized her as the proper asset holder and earner? Okay, that's fine too. I mean,
She came, you know, and she worried if he, like, in a couple of years, meet somebody, maybe another woman, she felt very stupid, go back.
Yeah. Well, again, I don't know what the division was. If it was unconscionable, then if it was terrible, if he got nothing, you know, how long was the marriage? Why wasn't he doing his share and pulling his weight? Were sworn financial statements exchanged for supporting documentation? Did he look at them all with counsel? Maybe he signed an acknowledgement. His lawyer probably said to him, what are you doing? You know, and if he said, I don't feel right about this, I'm going to do it, then that's something that it's his choice. I mean, adults are given the freedom in this country to contract. So
It'll be difficult.
it'll be difficult.
Everything like done properly, for that guy will be difficult to come later and try to get it back.
It will be very difficult, but I mean, I'd have to know a little bit more as to why he did that and what his lawyer said. Did he have a lawyer?
Yes, he did
Well,
that.
That's good. That's good.
But he just, I don't know why. Probably feel not right to grab something.
Well, and that's very ethical of him if that's what he wants to do. But you know, if it was too ethical, if he's disadvantaged himself somehow, there is a common. If they're married, there's property division. Because judges don't want to have to reach in and hear, I paid the mortgage, and I bought the groceries, and so provided the child care, and so got up at 6 a.m. to go to work, and so stayed up at 2 a.m. to do the child care feedings. The judge is not going to get into that level of detail, and they can't. People start telling things, you know, stories and lies, and they can't. So there is a basic principle of equal property division, but you can waive that right. Now, it's the more information that's in that separation agreement, the better for the person who ended up with more of the assets. So it should be very detailed.
There's some reason why it happened.
And there should be a waiver in there, at least a spousal support waiver and hopefully an equalization waiver. I guess it wouldn't be a waiver, but it would be a detailed, you know, I understand I didn't get 50-50. Under the Family Law Act, I've agreed to an unequal division of that family property. So hopefully it was drafted well.
Is there a statute of limitations?
Yes. The statute of limitations is if you're divorced, you have 2 years to make the claim, and if you're separated, you have 6 years. Yes.
So if you have a separation agreement, and not a signed one, that is just ongoing, but it's been, let's say, 6 years, can they just continue to ask for updated financials from the other person?
You can, but it depends on what you're looking for, right? Because if you're doing asset division, if you're doing equalization, the time limits is for spousal or child support is for the asset division, for equalization. So if you're looking for equalization, I always tell people the date of separation is very, very important. It's like a snapshot in time of your finances. It's like a spreadsheet. You know, what did you have on that day? Because 6 years later or 5 years and 6 months later, if you have more, if you have less, unless you're claiming under Sarah, like Michael Cochran said, you know, and that's a hard argument to make. It doesn't matter exactly.
Yes.
So you want to use those numbers on the date of separation, and in the column there is a today column, but it's really not going to be that relevant.
Yes, so why would a lawyer keep asking for that?
Was it a married situation? You're seeking there's equalization being sought?
There is, but I mean, this is like, they're asking for current financials, which have nothing to do with the date of separation. It's almost 6 years ago.
There is also a tenet. Judges don't like to make decisions if they're in court. Judges don't like to make decisions, I don't know if your parties are, they don't like to make decisions based on old or stale dated information. So even though the date of separation column won't change, those values won't change, the today date could be relevant when it comes to how's the person going to pay if those other assets in the middle column have been devalued over time, don't exist. Judges want to see an updated financial statement every month, or from at least 30 days prior, if not sooner. If I have a court date in January and I'm going back in June, I have my client either update his or her financial statement, Or I have them talk to my clerk, and if there haven't been many changes, my clerk will swear an affidavit saying I spoke to Mrs. Smith, and Mrs. Smith says there hasn't been anything substantial. It's changed on her sworn financial statements from last January, so they don't have to do a new one. Doing a new one means they have to come in and meet with you and sign the whole thing up again. So judges want current information. It's a good question, though, because for equalization, it really shouldn't make a difference. You know, some people, like I was saying earlier, they just want to see the information. Another thing, though, that people do, and maybe this is the reason you're entitled to updated financial statements, is I have received, over long cases, I have received so many different versions of financial statements that I compare them. So if I have one from 2008, and I see another one come in 2010, there's usually a whole host of different things on there. There may be joint accounts, or not joint accounts, my client would have shown that. There may be sole accounts that show up that I didn't see before. And then I say, oh, when did you open that account? If it's post-separation, that's fine. If it's not, it wasn't disclosed earlier. So you can get a lot of information from comparing financial statements. People forget what they put down. They show a today pension of $120,000. And I'll say, well, that's funny. Your pension was at zero in 2008. How is that possible? Oh, they say, you know, and then we can get the information. So people are less likely to lie, I think, on a current financial statement if they think they don't have to, it's not for division purposes. So anything they put on there is free and clear. I always compare them. You might come up with
Where do
something.
you put if somebody disposed of assets? Would it like a year? Where do you put it?
Before the date of separation?
Yes, somebody like, as I already asked question, I'm working with the client now, and the woman, she got just 1% of the property that jointly owned with her son from the previous marriage. And that property down payment given to the son from inheritance of the father.
Okay.
So, and now she's separating, divorcing with this new husband. Can that husband get the half of that property if he got independent legal advice and he signed off that 1% back to the son?
Well, if you signed off and you got independent legal advice, again, it's all
But
through contract.
he used to live there, so can he say, oh, that was property and there are more than 1%?
It's, and I heard Michael talking about this, and I wanted to pipe up and give my 2 cents.
That lady, she's going crazy.
Well, it's, you know what? It's not an easy issue, so it raises a few different things. So I would say that if there's a signed contract and the parties involved signed it,
Like I think
that's,
a year before.
but as a caution, the matrimonial home is somewhat sacred in the family law realm. Okay? So if it's 1% and everybody's signed on and all of that, that should be okay.
There's another property, matrimonial home, but they
Well, one matrimonial home probably won't affect another. You know, you can have a cottage and a house and all that. They're not going to choose one over the
So
other.
we still can go and
So-
claim half of that.
Just like, can we just, like, say your questions maybe to the end?
Okay.
So we can get done?
Sure, sorry.
We are in.
Yeah. No, I could talk about this stuff all day. Sorry, I'll move it along. Okay. Oh. Okay, so now we're moving into, I think, a bit of a more complicated area. A lot of people have trouble with this, lawyers have trouble with this, clerks have trouble with this, and it really seems to baffle the public. I think it should be made a little bit easier. The Interjurisdictional Supports Act, or ISOA, is handled by the Family Responsibility Office, which we call FRO. They have a unit in there called ISO. That's the Interjurisdictional Support Orders Unit. So, you know, you'll find more information if you ever wanted to look into ISOA or if you wanted to look into the ISO unit. It's under the hubris of FRO. It's on their website. There's more information there. And it's there for a reason. A lot of the intent behind drafting this legislation in 2002 was to replace previous legislation that really didn't solve the problem of enforcement. So when you have an order, that's great. You know, you get your child support order. The only time it really becomes important, and you need other people to recognize it, is when someone's not complying with it. So who enforces it? So that's, you know, And of course, enforcing orders is what FRO does. So that's the connection there. Of course, they do a lot more than just enforce orders or tell you where to register an order for enforcement. They can help you get an order. Now, it's not a system, and this is why I've got a few more things here to share with you. There is a, let me just find it here. There are other things that you can do. You don't always have to use FRO, which is the complicated part. FRO, some of the issues that I find with the ISO unit and going through FRO is that you can lose control of the process. For instance, as a lawyer, I go to court quite often and I argue for my clients. And I had an issue one time with a child being in the Brampton jurisdiction. The recipient mother was in the Brampton jurisdiction. The payor had quit his job. He was earning about $85,000, and he'd gone with his new girlfriend to Canmore, Alberta, let's say, somewhere in Alberta. And I went into court and I explained this to the judge, and there were also issues. She'd never received support, so this would be a first-time order. She'd never received support. The child was 9. She was afraid. She was intimidated. So the judge said, well, fine, I'll grant you an order. And we'll be able to come near the child. You know, they've never had any kind of access. They've never had any custody. She'll get full custody. Not a problem. I can't help you with the support. And I knew that sometimes judges would help you while you're there. This judge wouldn't. So we said, okay, we talked about this. We're going to have to pursue the support through ISOA. And 2 years went by, and by the time I left that law firm, I never heard anything from ISOA. So that was a bad case scenario. We filled out all the forms, we sent it all off, and he was now working as a house painter. She had friends in common. She thought he was working for $11 an hour. Whether it was over or under the table, we don't know. And she said, but, Ms. Vanderschoot, why can't I get child support on the $85,000 job that he left? And I said, well, if I were arguing that, I would argue to impute income. He showed a capability of earning $85,000. He's, I guess, taken a year or two off to hang out in Canmore with his new girlfriend, earning a very meager income. He doesn't have that right. It's, he owes the child an adequate amount of support. And she said to me, will ISOA, or not ISOA, will the counterpart to the ISO unit here in Alberta as a reciprocating jurisdiction, will they go to court and make that argument for me? And I said to her, I hope so. And I've since learned probably not. They just simply don't have the manpower. They usually do not send a representative to court. Usually these applications are dealt with written material only. So you would fill out your Form N as an applicant, you send it off, you send it into the ISO unit. The ISO unit would send it off to their reciprocating jurisdiction, whether it's in California or Alberta or wherever it is, and you'll get something back hopefully. But he then has 30 days to respond through his jurisdiction, which is then sent back to Ontario. And if he sends in a notice of assessment showing that you earned $22,000 that year, you may get a support order on that, and you can appeal that. But you don't have the, the mouthpiece. Can I call myself that? You don't have someone in court trying to put forth your case like you would if you were in there, if you were in that jurisdiction.
So, Christine,
yeah?
with this interjurisdictional support order and the FRO department, is it the whole idea to sort of get these, before the time they called them dads or whatever it was, to get this money that they owed? So you're telling me, so if you register with the FRO office for support, you need an order for them to go after the dad for
yes.
whatever he owes you. So once you receive that order, which could take, I guess, a year, 2 years.
Let me back up. I'll make it more clear. I didn't explain. In the ordinary course of events, when both parties reside in Ontario, you can either agree to pay support amongst yourselves, what you think the right amount is, and it should be the table amount, and you can draft it into a consent order and send it in to the court. You can file a separation agreement with all of the terms handling the breakdown of your relationship in there, including support, and you can file it with the court under Section 35 of the Family Law Act. I recommend that people do file that with the court, or you can get a judgment from a judge. So let's say you do any of those, you've got either an order then in the end or a filed separation agreement, then the court takes it upon themselves, which is great. They send that into the Family Responsibility Office, and there's a presumption that the Family Responsibility Office will enforce that order. Now, a lot of people withdraw voluntarily from the Family Responsibility Office because if you've got a negotiated separation agreement or you've got an order, but it's a reasonable amount, a lot of people don't want their employer to be involved and have FRO garnish their wages, especially if they've never not made a payment. If they say, look, I'd rather just pay a check or make a transfer, let's keep my employer out of it, why have a garnishment? Why should that be, hopefully it's not known throughout anyone's workplace, there should be confidentiality, but some people just simply don't like it. And normally that's fine. In a situation where there is no order, or the other person, let's say there's an order made in Ontario, and the other person isn't here, then there has to be a mechanism for enforcing. So, FRO, you can send in your order. Let's say
But
you
they
have
can't, they don't be able to enforce it somewhere else.
well, they will. The FRO will send it through. Yeah.
So address issue, that's what you said. You sound like second party. If the case went to FRO, second party has an option not to follow. Like I want to make arrangements, I will pay.
Yes. It's got to be both parents or both parties have to sign the withdrawal.
Well, I was willing to, with my personal, I was willing to pay to FRO. I wanted to withdraw. Of course, I couldn't because my ex did not agree. And so I agreed, fine, I will be paying through FRO,
Yeah.
which was good. But they still were saying, I was coming from the same situation like you. I accepted that, I wanted to pay,
Yeah.
and I was paying, but they were chasing me, requesting
That's-
data of my employer, so I had to very politely show them middle finger. I said, as long as you are getting money, back off.
Well, and that's the
And they
thing.
left me alone.
But that created a lot of trouble for you.
It was, yeah, absolutely unnecessary. I didn't mind.
No.
It was coming from my account automatically, so it wasn't an issue. But it looks like there is an option you can
Yes.
go and say, I will pay voluntarily. FRO didn't seem, at least at that time, accepted. They wanted still get my employer information. They wanted to garnish my all the child support.
Correctly. You can set something up with FRO yourself. You would have a caseworker, and they would, have to be agreeable. I've had different answers. I've heard this through my clients. I try not to call FRO. If I call FRO, I need an authorization from my client to do so, and it's a large bureaucracy. So what I know about FRO is if you send them a fax, it'll take 5 or 6 days to get to the distribution center, and then another couple days to get to the person. So it's tough, but they do their job in the end. It takes a little bit of time. You really want a good relationship with your caseworker, and you want to keep your lawyer not involved if possible, because that costs you money when your lawyer has to call in. But like with any other scenario, you're going to hear sometimes some different stories from different clients who've dealt with different caseworkers. So I've recently had a case where this fellow who didn't handle the procedure properly and had an award made against him, in September he said, oh my God, they're enforcing a 2005 order against me. I don't earn that kind of money anymore. And I said, well, FRO won't change the level of support until you change the order. You can have an amending agreement, a consent order, or we can go back to court and get another order from the judge. I said, if they're going to keep enforcing that against you, they want to take your driver's license, you need it to work, why don't you call them and see if you can negotiate some payment in the interim. So he was lucky he was able to do that. Many months have gone by, he hasn't always been paying them, and now they are garnishing. They've sent him a notice. So he's again called me and said, what can you do? Well, I really can't do anything at this point. I can't bring a motion, there's something called a refraining motion. But if they've been through this with him already, a refraining motion I think would fail. And I think that they would simply say, look, you got to pay your support. If this had gone through the normal processes, if it had become a court order, you would have filled out something called a support deduction order. It gives all that information, your employer, your home address, your banking information of both parties. And it goes with the order for the separation agreement to FRO, and they open a file. If someone, changes jobs, they need to update that information, or they'll start to fall into arrears.
Sorry, did I hear you say that they would take your license?
Take can take your driver's license for non-payment. And it gets worse than that as well. They can take your passport, if it's a Canadian passport, they can take it.
Driver's license, I figured the rest of it, but I didn't realize they could take the driver's license.
Oh yeah, any federally issued, or provincially I guess, issued documentation, they can take your income tax return.
How does that help the situation?
Well, I think that it's...
It forces the situation.
And it usually, it can, I mean, I've actually been to court with my client, the recipient, tugging at my arm saying, he drove here. His license is suspended. How do you think he got here? He drove here. What are you going to do? You know, and the courts basically, I think, turn a blind eye because about 80% of people, this is a statistic that I've heard and can't verify, but I've heard that about 80% of people who are in arrears and who have their license suspended drive to court. You know, is there the manpower? Is the bailiff going to follow that litigant out, see if they're going to the bus stop, or see if they're unlatching and getting into the driver's seat? I don't think they do that.
What is the intent? Is it just to provide
force
person into making stuff, doing something?
Well, I think the thinking probably harkens back to the fact. I think the thinking probably harkens back to the fact that the federal child support guidelines are based on actuarial. Thank you, actuarial calculations. So if someone's earning $95,000 a year and he says, I can't pay my $820 a month, and the arrears build up and he hasn't paid and now he owes $5,000 or $6,000, I think the courts aren't very sympathetic. I think they say, okay, we're not playing games here anymore. We're going to make your life a little harder. We're going to stop just sending you letters, and we're going to take your license. And a lot of people do come up with the money at that point, because I think the thinking is that the obligation has been set at a reasonable level by financial people smarter than myself, and the judges don't want to tangle with that or change that, and definitely FRO doesn't. Now, of course, there's lots of instances where people lose their jobs, and they don't know enough to get that order changed. Or, in my fellow's situation, they approach the opposing party, the recipient, and they say, here's my termination letter, I'm not earning this anymore, and she says, too bad. And then we see costs against her when we go back to court and prove that income. Meanwhile, he's receiving these threats from the Family Responsibility Office. So the lesson here is move quickly. The firmer lesson here is when you have the order, and if you can, initially get the other person, the recipient, to withdraw. Because the other person, if you stop payment, they can, for about $50, they can re-register with the Family Responsibility Office and start the whole thing going. But you don't want that looming when you've always paid. You know, you don't want that. One missed payment, if you're already with FRO, will cause you a lot of trouble. Whereas if one missed payment is corrected and you're not already in the FRO regime, you probably won't experience any difficulties.
So if I heard you correctly, any court-ordered support payment goes through FRO unless you both agree to withdraw. And FRO is national across Canada.
No, FRO is provincial, but they have provincial counterparts. So in Alberta, it's, the enforcement, I can't remember now, but it's not, the acronym isn't FRO, but it's something similar.
Somebody moves to Texas.
Then you can, again, use the reciprocity. So you would definitely have, you would have to take the action then. You would have to find out what jurisdiction they're in, which again, can be a hurdle. So you don't always keep track of where your ex-spouse is, especially if they don't have contact with the children. I had a situation slightly different, but this one fellow had tens of thousands in arrears, probably closer to hundreds of thousands in arrears. And the Family Responsibility Office had been after him. He disappeared, and they wanted to garnish his income. He was no longer working. They were looking to garnish his pension. And I had to call and find out the pension information. They really didn't want to give it to me. And the person I spoke to probably shouldn't have given it to me, and I had to give it to FRO. Because this person had gone, last he was heard of, he was in Russia. But his pension was a Canadian administrated pension. He was retired, he was entitled to that pension. We were hoping he hadn't been paid out in a lump sum when he was leaving the country. And periodic payments were still being made, so we were able to find him. Now, I can't, jump on my broomstick? I don't know. But anyway, I can't jump, on a plane and get him to pay. I then gave it to Fro.
So Fro can enforce it if it's in Canada, but if someone lives outside Canada and they have no Canadian assets or anything, then you're out of luck, you gotta go to the other guy's country.
It gets complicated. There would have to be a reciprocating jurisdiction. In other words, the comity between judges has actually led to cooperation. So judges, and I just wanted to find something here too, setting aside. So we don't always agree with other courts either in Canada. There are instances where we can receive an order, and there's some examples here. We can receive, so I'll just read you this information here. It says there's no procedure in the ISOA to set aside registered orders made in other Canadian provinces that are registered in Ontario. So if it's interprovincial, you can't set it aside. You're fine. The flaw is not going to be found. We're under the same general jurisdiction. There is differences in family law throughout the provinces, especially when you get to Quebec. But, okay, the grounds to set aside support orders from reciprocating jurisdictions outside Canada. So other countries are set out in Clause 24B. So they have thought about it. And basically what they say is, did the person that the order was made against, that Ontario is being asked to enforce, have an opportunity to be heard in that country? And by being heard in that country, basically they mean, was the person given notice? Was the person given the opportunity to participate? So they have some examples here. For some reason, they're all from Poland, and I don't know why, but there was a Polish order that was set aside. It was unrealistic to expect a Canadian respondent. So the applicant's in Poland, the respondent is Canadian, of very limited means, so it was unrealistic to expect them to, participate in the process fully. And in the absence of their participating in the process, the other person, and I'm not saying that they did this, but it was believed by the Canadian judge that the other person misled the Polish court as to income. Apparently the person in Canada, the respondent, earned around $7,000, and a huge support order was made that's not in line with $7,000. So that led the Canadian judge, rather than to rubber stamp it and say, sure, no problem, we're going to honor this order, we're going to pursue this order on your behalf, the judge said, that doesn't look right to me. And the judge didn't register the order. So, our judges are...
So is it only with certain countries that...
but these are reciprocating countries too. So Poland was a reciprocating nation. But I guess if judges think something didn't go right, it's a difficult place for a judge to be in. There's generally a principle of comity between judges. In other words, judges will respect the work and the decision-making of the foreign judge. But I guess, judges also have a lot of common sense. And if they see that someone's providing them with information in Canada, they earn $7,000, and they have other information that wasn't presented in the Polish court for various reasons, it wasn't heard, then the Canadian, the ISOA Act in Ontario, the Ontario judge can rely on Section 20 of the ISOA and insert their own common sense into the equation. Sorry.
Reciprocating meaning that we with respect to judge judgments?
It means that I wouldn't go that far, no, or we wouldn't have Section 20 allowing our court system or our court judges in certain instances not to enforce the orders or register the foreign orders. I would say that we've agreed with other nations and interprovincially to come up with a mechanism for these orders to go through. There's a procedure for it. And I really have no idea what the equivalent of ISOA looks like in Poland, but I hope it would have similar characteristics. So there would be, here it says, a court may set aside, this is 20 sub 4B, the court may set aside the registration, the order basically, if it determines that in the proceeding in which the order was made, a party to the order did not have proper notice or reasonable opportunity to be heard. So there's a slew of case law on that. Someone's been given notice of a proceeding in Germany, and they must attend. And it's going to happen in 3 weeks. So that's simply not enough time to make travel arrangements, get time off work, prepare, educate yourself if you're a self-represented party. So that was, orders made in that circumstance when you don't show up in 3 weeks' time because you couldn't get there, you couldn't organize. Those orders likely will not be registered in Canada or in Ontario. So So there's another one here, if the order is contrary to public policy. So that would fall under the example I gave you where the child, the person, the support payor earned $7,000. And there was an award for, I can't remember the details, but I think it was about $1,000 a month made in Poland. It's against public policy. It's outrageous. It doesn't make sense. Or the court that made the order did not have jurisdiction to make it. Courts make mistakes. And I was talking earlier to you actually about this. I wouldn't say that I wouldn't go so far as to say that the California courts don't have jurisdiction, but there is something called continuing exclusive jurisdiction. That's a federal statute in the United States that basically means that if certain circumstances continue, so continuing exclusive jurisdiction, CEJ, if there's a continuing circumstance, let's say one of the parties remains in the jurisdiction, that's a continuation of circumstance to some judges. And therefore, you can't have an order made in another jurisdiction. They retain jurisdiction. And the way we like to think about things, the way the reciprocating jurisdictions tend to treat this type of issue is if there is a payor in Ontario, so let's say mom is in Ontario, dad lives in California with the kids. Mom's the payor. Where's the best source of information about her income? Where's her income tax return going to be done? Where does she pay her taxes? Where does her employer, where is that person housed? Ontario. So a support would be brought then in Ontario. So the California person would fill out their forms, they'd be sent to an Ontario court, an order would be made here, it would go back. So that's how that would work. Well, the CEG, California, may say, we've still got these people here, or some of them. We're going to retain jurisdiction. And that really creates, you've seen this, it creates a paradox. And we don't like it as lawyers. I mean, I've had this happen to me as well. And you say, wait a minute, and I mean, you don't win those. California retains jurisdiction. So you could argue them. I mean, I couldn't argue in California, but I mean, through letters and correspondence, I can say you've got it wrong and give them examples. But if they don't want to change their views, there's really not so much you can do. So I don't know how much time I have. I'll go through, yeah, definitely. So the PowerPoint, like I say, is a bit more technical, and I'm going to get a little bit of that. We talked about the background. Yeah, there's Quebec's been carved out because we're just a little bit too different. Anyway. So it replaced an earlier act, which we don't need to know about. And it is about establishing protocol, procedures, arrangements, basically. That's what it is. And again, yes, there are some limitations, and I talked about this a little bit in my paper. If there are cultural or legal difficulties or differences that just don't fit under, let's say, a common law system, it can be very hard. I mean, there's just no way to try and get a child support system if you're dealing with, let's say, a corrupt judiciary in a different country. You just can't. And judges are very careful and circumspect as to who they recognize as corrupt and who they don't, and I'm not going to say anything. But an easier example would be where child support is not viewed as a right of the child, or spousal support is something that's a foreign concept. For instance, some of the Middle Eastern countries may not recognize spousal support or child support. I mean, and this is slightly off topic, but I have a very, very good friend who's senior to me, and she recently gave a talk at the Family Law Institute. She's Iranian Canadian, and when she was, I think she was about 10 or 11, her father, who had contacts in Iran, said they were going to the movies or something. The parents were separated. She was used to going out with her dad. She was there until she was 17. And she was allowed to call, and he took her to Iran, and he got a passport for her. Didn't need the signature of the mother, and she was abducted. And she came back to Canada and became a family law lawyer. And she's written extensively on this. And she has tips as to how you can try and stop that from happening, what you can look for. But I mean, even with an order, a non-travel order, it's hard. If someone can get a passport from a foreign jurisdiction without the other parent's signature, in Canada you need both parent's signature for a passport, obviously.
You do, you have travel, when you want to travel.
Well, you can get an order in situations where one of the parents has disappeared or has completely removed him or herself from the child's life. You can get an order that's dispensing with the necessity for that parent's signature, with dispensing with the necessity for a travel consent. I always say to my clients, even if that the other parent is involved in the child's life, and you get a signed travel consent and you travel somewhere, bring the order. Because people always say, oh, I have sole custody, I don't need travel consent. Sometimes you will, depending on the border guard. Because the other parent may be a 39.2 access parent who only almost has shared custody or has some decision-making off the orders. Always bring your court order, the official stamped copy that the courts give to you after you've been there that day. You usually get it within 4 to 6 weeks. So you bring that with you.
My ex-husband had to meet us in the States, they wouldn't allow us back.
They wouldn't allow you back here.
Which was the weirdest thing.
What did you have with you?
I had a notarized letter from my ex, which was years ago.
What did they tell you? They just said it's not good enough?
Not
We don't-
good enough.
People do forge documents, and I guess some overzealous border guard didn't want to be culpable.
Yeah, he had to come and meet us. Which is
No.
fine. But I mean, things are better now.
I've heard 1 or 2 stories like that, but not many. Yeah, and it's tough because you did everything right. You probably went to your lawyer and said, how can I stop this from happening again? And your lawyer probably said, uh-oh, I don't know. There is a list. I don't know if you want me to go slowly here. You can have a look at this list, or if you want me to email it to you, or you're not really too concerned about the list. It's probably information you can find online. Let me know. Okay, this is how they came up with this. So we can skip through that. This is important. So they carve out a difference here. They say that the ISO Act does not apply to any support applications made under the Federal Divorce Act. The problem for that, again, is jurisdiction. So ISOA is provincial. Divorce Act is federal. So that trumps or takes precedent over. So you can't have any kind of a process that's being led or relies upon the Divorce Act being administrated, I guess, through ISO, which is provincial. So it's just one of those dualities.
Why would you have a situation where it would only be under the federal enforcement?
Well, if you're married and you're getting divorced, you're going under the Divorce Act. You don't really have a choice. So you're governed then from there on in by federal legislation. Pardon?
Most married couples would be in that position.
All married couples.
Right.
All married couples. Common law couples, and again, we haven't gotten there yet. If you have a final order, even though you've received that final order of the separation agreement under the Divorce Act, you were married, and you want to apply to change it, you want to vary it, you can use ISOA for variations. Okay, we'll talk a little bit about the registration of orders. So some of the fundamentals, this is what I would take away from ISOA. Okay, this is what I would take away from ISOA. I would say the ISO unit under the Act can aid litigants in the following 4 areas. Registering a support order made in a reciprocating jurisdiction. So if it's made somewhere else in the reciprocating jurisdiction, they can help register it in Ontario so that it can be enforced. Okay? Just because you have a court order in your pocket doesn't mean anyone's going to enforce it for you. The powers that be, in this case the Family Responsibility Office, have to know about it. It has to be lodged with them for enforcement. So ISOA can do that. Number 2, registering a support order made in Ontario when the recipient lives in Ontario for enforcement in another jurisdiction. So I think we had that issue come up. You get your order in Ontario. The person receiving the child support, exactly, and the other person is in a different jurisdiction, like Alberta, let's say. Number 3, pursuing a support order when the recipient lives in a reciprocating jurisdiction and the payor lives in Ontario. So someone from California gets their support order because the CEG, they won't let us get the support order going. They've got to do it. Then it comes over here for enforcement. Okay? pursuing a support order when the payor lives in a reciprocating jurisdiction and the recipient lives in Ontario. So that's getting an order. So we've talked about some things here already, I think, that I don't really like about ISOA, that I've run into and found difficult. Primarily for me, those two things are there can be a delay. You're going through many, many levels of bureaucracy now, and I'm not at all blaming FRO or the ISO unit. They then have to usually deal with the reciprocating agency. And we just have no idea of what's going on, what their procedures are, but it takes a lot more time than it would take me to go to court. But it also saves people a lot of money and allows this cooperation between jurisdictions. You don't have someone having to fly to California and hire a lawyer there, and then fly back to Canada and hire a lawyer here. So a little bit of delay maybe is what we have to live with. I've got a situation right now too, and everything's going well so far, but you're supposed to receive the application. The Form N came in from ISOA, from the ISO unit. I think it was December 22nd, and we were closing our office. I thought maybe on a Wednesday, and we were closing our office on Friday for about a week and a half over the Christmas holidays. And it said that the responding materials were due in 4 days. It was due, I think, on December 24th, the last day the court was open, which was unbelievable. And of course I called, or tried to call the ISO unit. It was around, it was difficult. I had to call a contact that I know at FRO and get him to walk around and find someone from the ISO unit. There are two people in particular in Ontario that I know that work in the ISO unit as well. And someone called me back. So they actually emailed me and they said, okay, don't worry about it, but we wanted to start this process before everybody broke through the holidays. And I said, but according to the statute, we have 30 days to respond. And they said, well, I guess you're right. So they were trying to give us 2 or 3 days. That can be a problem, but it doesn't usually happen. And again, it should be written submissions. So we prepared our written submissions. My client came in at the appropriate time, signed everything, and we sent it in. And we got a response from the court saying that the judge, though, was going to read the written submissions and make a ruling, except the applicant in New York City had hired her own lawyer here, and that lawyer wanted an oral hearing. So my response obviously was, this is a huge waste of taxpayers' money. Why is ISOA, who's very busy, the unit, getting involved when they're very busy? Somebody else could be receiving their services. When this person is of means and has hired a lawyer, she could have just hired the lawyer initially. She could have skipped this process. This process is set up for litigants that don't have the type of means to pursue their own order. So, and he said, and I said, well, I'm going to bring that to the judge's attention because it's a waste of resources and court resources. If you ever go to court, it's very busy. Sometimes, there's 17 people in front of a judge, depending on the court. So if we can cut some of that out, that would be useful. I've told you already about the payor who was... Now, the last thing we haven't talked about is a torn into a jurisdiction. I'm not trying to frighten anybody because you can torn into a jurisdiction with the stipulation that you don't agree with that jurisdiction and that you're going to fight that jurisdiction, but you must do that properly. You must do that in a very obvious manner. And you must, I would always say, you should use the words, I do not torn to the jurisdiction. In other words, just because I'm putting in my materials in a timely manner, so you don't have a default ruling in my absence, it doesn't mean I'm agreeing to this. I don't agree to this jurisdiction. It has happened in the past, we're going back 5-10 years, when somebody answers an application, even though they don't think it's the proper jurisdiction, and a judge has said, well, we've got your answer. We're going to, that's you're consenting by your actions, basically. And that's something to be avoided. So I think on that note, I will end my talk, unless there's more questions. Yeah, interesting.